Well, this is an election year in the United States, and we have two candidates who are very soon going to be debating all of the important topics that face everyday Americans. And one of the topics that is going to be front and center, guaranteed, is the abortion issue. That topic is going to be front and center. And abortion is always debated on both sides of the aisle very, very strongly. And specifically this year, the reason why it's going to play such an important role is the fact that there's a monumental decision that came out from the United States Supreme Court in 2022. It was the Dobbs decision, Dobbs versus Jackson Health. And Dobbs versus Jackson Health uprooted and reversed the law that was in place in the United States since 1973, which came from a decision called Roe versus Wade. Now, there is a very important part of the Dobbs decision that does need to be debated. However, I guarantee you that it's not going to be debated because both parties are just going to echo their regular party lines about pro-choice or pro-life, and you're not going to really be hearing really what needs to be debated. So that's why this video is coming to you, so that you can really understand what does need to be debated after the Dobbs decision. And also, a lot of people, I think, have a lot of misconceptions and misunderstandings about really what Dobbs does. So that's what we're going to be doing in this video, explaining Roe versus Wade and then explaining what Dobbs versus Jackson did, and the main point, which gives us a very large question that needs to be answered as a result of Dobbs, which you're probably not going to be hearing many people talk about, but you yourself will know this issue. Now, as a little disclaimer, just to be very clear, this is not a channel that's devoted to political commentary. I don't choose any sides of the political aisle to push onto my viewers. I simply just provide the law and the facts and the evidence, and that's what I do when I'm analyzing trials, when I'm analyzing rules or case law or statutes. That's all we do here, is we provide the law to you, we ask some questions, and then we leave the decision-making and the opinions up to the viewers. So without any further ado, let's jump into first Roe versus Wade. So Roe versus Wade, a 1973 case. What happened there, that there was a Texas statute which prohibited certain types of abortion. So that statute was challenged. And what Roe versus Wade said was the following. But before we jump to the actual substance of the opinion, they give a very nice paragraph leading into everything. And this is what it says. We forthwith acknowledge our awareness of the sensitive and emotional nature of the abortion controversy, of the vigorous opposing views even among physicians, and of the deep and seemingly absolute convictions that the subject inspires. One's philosophy, one's experiences, one's exposure to the raw edges of human existence, one's religious training, one's attitudes toward life and family and their values, and the moral standards one establishes and seeks to observe are all likely to influence and to color one's thinking and conclusions about abortion. In addition, population growth, pollution, poverty, and racial overtones tend to complicate and not to simplify the problem. Our task, of course, is to resolve the issue by constitutional measurement, free of emotion and of predilection. And that is exactly how I approach this. We try to leave all the emotion aside and just analyze what we have based on the Constitution and the case law. So, also, there was a number of different legal doctrines that come out in the Roe versus Wade and the Dobbs decision, which I think is confusing for a lot of people. And that's maybe what's making it very difficult for a layman to understand. So we're not going to be jumping into every single legal doctrine that's discussed because it's not really so important to the discussion that we need to have today. And the discussion really is the following. Is there a fundamental right guaranteed in the Constitution for a woman to get an abortion? A very simple question. Is that right found in the Constitution? That's the question that we have to answer. And Roe versus Wade also attempts to answer that question. So here we go. Is there anywhere explicitly in the Constitution which guarantees a right for a woman to get an abortion? And for that, the answer quite simply is no. Go look through the Constitution. You're not going to find anywhere explicitly where it says that a woman has the right to get an abortion. So where does Roe versus Wade find the right for a woman to get an abortion? And by the way, it's not just a right, it's a fundamental right. And there's a difference between whether something is a fundamental right or if it's a different kind of right. And this is really more in the legalese world. And the reason is that a fundamental right is going to be reviewed, that if the government tries to intrude or limit or restrict that fundamental right, it undergoes what we call strict scrutiny, which means that the government is very limited, much more limited in how they're allowed to regulate a fundamental right. So if it's a fundamental right guaranteed in the Constitution, then the government has to be very hands off. And any type of regulation that they want to impose, it has to go through this strict scrutiny, which we're not going to get involved with, so we're not going to confuse anybody. But it is a difference between whether it's a fundamental right or not. So there's nowhere explicitly in the Constitution. So where does Roe versus Wade find any sort of right? Well, they find it in the 14th Amendment. And there's a number of different amendments which they discuss, which possibly could also show that there's a fundamental right for a woman to get an abortion, but they believe that it's in the 14th Amendment. So what does the 14th Amendment say? 14th Amendment says the following: no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. So this is specifically an amendment that's talking to the states. Now, remember, there's really two different systems. There's the federal system and there is the state system. The federal system generally talks to the federal statutes, the Constitution. It's in the federal system. It really doesn't have much to do with the states. However, here you have a specific amendment which is talking directly to the states. So this the states actually have to listen to. So the 14th Amendment says no state can do this, nor shall any state deprive any person of life, liberty, or property without due process of law. So those are the important parts, that a state cannot deprive any person of life, liberty, or property without due process of law. So what does that mean, that the state cannot deprive you of liberty? What does liberty mean? Well, Roe versus Wade says the following: the Constitution does not explicitly mention any right of privacy. So where is there any sort of right to have any sort of privacy in the Constitution? It's not explicit in the Constitution. Well, they find that in the word liberty. This right of privacy, whether it is be founded in the 14th Amendment's concept of personal liberty and restrictions upon state action, as we feel it is. So here's Roe versus Wade saying specifically, they believe that it's the 14th Amendment, which provides liberty, which also includes right of privacy, or as the district court determined in the 9th Amendment's reservation of rights to the people, is broad enough to encompass a woman's decision whether or not to terminate her pregnancy. So there you have it. Roe versus Wade says liberty tells you privacy. Privacy includes a woman's decision whether or not to terminate her pregnancy. Now, once the Roe versus Wade court determined that a woman's right to have an abortion is a fundamental right, which is implicit in the 14th Amendment, now they have to go through this whole balancing act between when is the government allowed to impose any sort of regulations, at what point, and that's where they come about this trimester, how they work with the trimesters. Okay, that's Roe versus Wade. But again, back to the main point is that they find this right in the 14th Amendment. Now, the next case really of significance is Planned Parenthood versus Casey. Now, Planned Parenthood versus Casey, one of the parties wanted the United States Supreme Court to reverse Roe versus Wade. That's essentially what they asked the court. Reverse Roe versus Wade and say that there's no right in the Constitution for a woman to get an abortion. And they declined to do that. The United States Supreme Court declined to do that, and they cited as a big problem, a big impediment for them being able to overrule and reverse Roe versus Wade as something called stare decisis. Stare decisis says that when you have the United States Supreme Court that already issued an opinion on a matter, the next United States Supreme Court can't just ignore that opinion and just say, you know what, we're not interested in that opinion, let's just overrule it. That's not how it works. Now, there is, of course, there is a mechanism in which you can, if it meets a certain standard, to overrule a previous United States Supreme Court decision. That's already been done throughout history. But Planned Parenthood did not feel, or in the Casey decision, they did not feel that the Roe versus Wade, the decision in Roe versus Wade deserves to be overruled at that point, and therefore they felt that the essential holding of Roe versus Wade should still be upheld. Now, they did implement a lot of different changes to Roe versus Wade, but the essential holding they found we are not going to overrule. Now, they did impose a lot of differences, but we're not going to analyze them because really everything was changed in Dobbs. So let's go back to the initial question that Dobbs was dealing with, which was the first initial question that we started off this video with. where in the Constitution does it say that a woman has the right to an abortion? And again, it's the 14th Amendment. That's what Roe versus Wade felt, because the word liberty. Liberty without due process of law, that encompasses the right of privacy, which also encompasses the right for an abortion. So Dobbs takes the following approach. First of all, how do you define liberty? How do you define liberty? And they say the following: liberty is a capacious term. As Lincoln once said, we all declare for liberty, but in using the same word, we do not all mean the same thing. Meaning everybody wants liberty, but liberty to you means something completely different to me. In a well-known essay, Isaiah Berlin reported that historians of ideas had cataloged more than 200 different senses in which the term has been used. So 200 different ways that liberty has been used. So you can't just say, well, let's just look up the dictionary what liberty means, and that's what the 14th Amendment meant. You can't do that. In interpreting what is meant by the 14th Amendment's reference to liberty, we must guard against the natural human tendency to confuse what that amendment protects with our own ardent views about the liberty that Americans should enjoy. So you got to be careful with this. You can't just say, well, we believe that all Americans should have a certain liberty, and therefore that also must be what liberty meant in the 14th Amendment. You can't do that. It has to have a definition. There has to be a mechanics in how to define a word in the Constitution, not just with what we feel Americans should have. That is why the court has long been reluctant to recognize rights that are not mentioned in the Constitution. The court has been reluctant. We can't just recognize rights that are not mentioned in the Constitution. Where is it going to end? Substantive due process has at times been a treacherous field for the court, and it has sometimes led the court to usurp authority that the Constitution entrusts to the people's elected representatives, which here they're saying you got to be careful that there's a difference between what the job of the United States Supreme Court is and the job of the legislators in the states. And this is where they're giving us a clue about where they're going with this decision. As the court cautioned in Glucksburg, we must exercise the utmost care whenever we are asked to break new ground in this field, lest the liberty protected by the Due Process Clause be subtly transformed into policy preferences of the members of this court. So you got to be careful, because if you just leave liberty open to whatever the members of the court decide, well, then whatever policies the members of the court feel important, that's what they're going to read into the statute. And that we can't have that. There has to be a specific definition. Now, this really leads us into the discussion of what does it mean, due process. The 14th Amendment, again, 14th Amendment says, nor shall any state deprive any person of life, liberty, or property without due process of law. What does that mean, that the states cannot deprive a person of life, liberty, or property without due process of law? Well, it actually means two different things. You surprised? A little complicated. So one way is called procedural due process. Procedural due process means that if the government wants to deprive a person of liberty or life, they have to follow a certain procedure. They have to follow a certain process. They have to follow certain rules. They can't just decide one morning to wake up and say, okay, we're going to take away your property today because we just feel like it. There has to be a certain process in which they follow in order to deprive a person of that property. Same thing, life or liberty. But there's also another category. And the other category is something called substantive due process. And this is a much more debated topic, whether substantive due process actually exists in the 14th Amendment. And substantive due process is where abortion would lie, which means that the government cannot just take something away from me because it's not justified. They can't just do it. They can't just take something away from me. It's not fair. It's mine. Forget about following any procedures. They just can't take this away unless they have a really justified reason to take this right away. So that's the question, whether that substantive due process is actually included and embodied in the 14th Amendment, in the due process of the 14th Amendment. So the Dobbs court is assuming that there is some sort of thing called substantive due process. But then the question is, okay, well, what qualifies for substantive due process, which is where abortion would fall? Abortion is not some sort of procedural due process. This is actually an argument of substantive due process, that the government cannot take away my right to get an abortion. So this is what the Dobbs court found. And they say that this is supported by all of the case law, that There's two categories of substantive rights, which are guaranteed by the substantive due process provision in the 14th Amendment. Number one are rights guaranteed by the first 8 amendments. Okay, that's pretty simple. The first 8 amendments of the Constitution, those are considered substantive rights, and those the states have to provide and can't take away from the citizens. Okay, well, abortion obviously does not fall within the first 8 amendments. So let's go to the second category. The second category is the following: are fundamental rights that are not mentioned in the Constitution. Okay, so that's pretty simple. Well, there's rights within the first 8 amendments, and then there's other rights. Well, how do you fall into that category of other rights? So there's two rules that they have to follow. Number one, is the right deeply rooted in our history and tradition? So if this is a right that's deeply rooted, let's take the right to get married. How about that? Okay, the right to get married, is that deeply rooted in our history and tradition? Sure, of course. People always got married. So that's something that's a right that's deeply rooted in our history and tradition. That would be a right that's protected as a substantive due process within the 14th Amendment. Next part. Is it essential to our nation's scheme of ordered liberty? So number one, is it deeply rooted in our history and tradition? And number two, is it essential to our nation's scheme of ordered liberty? And they talk about ordered liberty throughout the opinion, although they never really define it. But we're going to discuss what they do talk about when it comes to ordered liberty. But first, let's talk about the first prong. The first prong is the right deeply rooted in our history and tradition, which means that you have to find me the history and tradition that there was a right for a woman to get an abortion. And they do a search through history, and this is what they accuse the Roe versus Wade court from not doing an honest search of history, because they argue that if you do an honest search through history, you will not find that there was ever a right to abort a child at any stage. And this is essentially the analysis that they run through. Number one, they argue, and they cite a lot of history from this, that common law recognized that it was a crime at the quickening stage to do an abortion. Now, what does quickening mean? Quickening is just another word for the first felt movement of the fetus in the womb, which is somewhere between 16 and 18 weeks of pregnancy. So throughout history, it's been a common law crime to abort a fetus that's after 16 weeks. Okay, so that's takes care of everything after 16 weeks. Now, they argue, and they cite some citations and learned treatises for this, that even before the quickening stage, it was still not permissible. And the example that they give, there's actually a case which was very interesting. The case was the following. We know that there's something called the doctrine of transferred intent, which means that if you want to kill person A and you shoot the gun at person A, and then person A moves out of the way and the bullet hits person B and kills person B, are you guilty of homicide? And the answer is yes, 100%. It's called the doctrine of transferred intent. You intended to kill person A and you killed person B. Now, if person A was not a person, let's say it was just, a statute. So you were trying to shoot at a statute. And then all of a sudden that statute moved out of the way somehow, or somebody pushed it out of the way after you shot the gun. And then what do you know? Person B, or a person, was behind the statute and that person got killed. Well, then you would not have the doctrine of transferred intent in that situation, because you never intended to kill anybody. You just wanted to shoot at the wall. Well, the case was like the following. There was a doctor that gave a pregnant woman who was before the stage of quickening some medicine to kill the baby, to abort the baby before it was 16 weeks. And the drug actually ended up killing the woman. And that doctor was prosecuted under this theory of the transferred intent, since he intended to kill the fetus before 16 weeks old, and he failed, and he actually killed the woman, so he was prosecuted. So they argue in this case, you see that even before quickening, it was still considered a crime, and it was still impermissible because they're using the doctrine of transferred intent. Now, also, they cite some other cases and some other treatises which also show that even if it may have not been a crime of homicide, but it was still considered unlawful. It was still an unlawful thing to kill a fetus before it's 15 weeks. And nowhere could they ever find anywhere where it says or even implied that there was any sort of right to do it. And they cite many state statutes which held that it was a crime even before quickening. So all of the history Dobbs is arguing shows that the history and tradition was that there was no right. And in fact, not only was there no right to perform an abortion at any stage, but many states made it a crime to commit the abortion that was even before the quickening stage. And therefore, they conclude the following. The inescapable conclusion is that a right to abortion is not deeply rooted in the nation's history and traditions. On the contrary, an unbroken tradition of prohibiting abortion on pain of criminal punishment persisted from the earliest days of the common law until 1973. So the first prong, in order to be considered a substantive right, which would then qualify you for substantive due process, fails. It fails that it is not a right that is deeply rooted in our history and tradition. Now, what about the second prong? The second prong is it essential to our nation's scheme of ordered liberty? Now, they never define ordered liberty in the decision, but they do say the following. Ordered liberty sets limits and defines the boundary between competing interests. So you have competing interests here. You have the interest of the woman that she wants to have an abortion, but you also have the interest of perhaps the unborn child and the state. So how do you weigh the competing interests? That determining how to weigh that will give you ordered liberty. Roe and Casey each struck a particular balance between the interests of a woman who wants an abortion and the interests of what they termed potential life. So this is a term that was used in Roe versus Wade and Casey, which is what they called potential life. That's the fetus. That's what's inside the mother. And they themselves struck a balance, what they felt is the right balance between the interest of the woman and the interest of the potential life. But the people of the various states may evaluate those interests differently. So maybe the people of that state don't agree with the balancing that Roe versus Wade or Casey, Planned Parenthood versus Casey did. Maybe they think that a different way to balance them is appropriate. The nation's historical understanding of ordered liberty does not prevent the people's elected representatives from deciding how abortion should be regulated. So this is what the Dobbs decision is arguing, that this should be an issue that the states should decide about balancing those interests. Now, there is still another part of the Dobbs decision which is important, and that is the following. Finally, the court considers whether a right to obtain an abortion is part of a broader, entrenched right that is supported by other precedents. The court concludes the right to obtain an abortion cannot be justified as a component of such a right. Attempts to justify abortion through appeals to a broader right to autonomy and to define one's concept of existence prove too much. So if you want to argue that, well, I have a right to autonomy to make my own decisions about my own health, and my concept of existence is, let's say, that the baby is not considered a human until, 25 weeks, till it's viable or till a later point. So why don't we argue that would be considered the right also for a woman to have an abortion? So they argue, the Dobbs decision argues those criteria at a high level of generality could license fundamental rights to illicit drug use, prostitution, and the like. Look, my concept of existence is if I'm on cocaine. So I should have a right to be able to have cocaine because that's my concept of existence. That's how I exist. I exist through the medium of cocaine. So the Dobbs decision argues, well, that's obviously not reasonable, and therefore your concept of existence or your personal autonomy cannot be the deciding factor here, whether you have that actual right to terminate a pregnancy. Okay, so essentially what Dobbs concludes is that there is no fundamental right for a woman to have an abortion, and that's in the Constitution, not explicitly and not implicitly. And if you want to argue, if you want to go down the road of it should be implicit and it should fall under the substantive due process clause, if you want to argue that way, they argue, the Dobbs decision argues that no, because it doesn't fall within something that is deeply a right, that it was deeply rooted in our history and tradition. If it's a right that's not deeply rooted in our history and tradition, then it does not qualify for a substantive right. So that's their main argument. Now, there's one very big problem. Okay, so wait, let me just finish off the analysis. So therefore, because there's no constitutional right, the Dobbs decision says that it's not a fundamental right in the Constitution to get an abortion. But the states are still free to make whatever legislation their citizens want. So if you put it on the ballot or you ask your citizens, you're representative of those citizens, you ask the citizens, what would you like to do with abortion? Do you want abortion? Do you not want abortion? You can essentially do what you want. Now, of course, there is a review process, but doesn't fall under the fundamental right, which means there wouldn't be strict scrutiny, but this is getting beyond the point. The point is that the Dobbs decision is just saying that there's no constitutional fundamental right found in the 14th Amendment or any amendment. And therefore, we can't argue that this is we can't hold that it's a fundamental right under the Constitution, but the states are still free to essentially do whatever its citizens want in enacting appropriate legislation that deal with abortion. Okay? So they're not making it, Dobbs' decision is not making abortion illegal. They're not saying you're not allowed to do it. They're not taking away the choice from a woman. All they're saying is that it's not in the Constitution, and therefore the states are free to make whatever laws or rules about abortion that they want. Essentially, of course, everything is subject to a review process, but essentially that's what they're saying. Now, there's one very big problem that Dobbs has to deal with, which probably most people aren't talking about, but there's really a very fundamental problem with their thinking, okay? And this is it. The problem is that if you start looking through all of the United States Supreme Court decisions that dealt with other areas of privacy where they found that there are rights with respect to privacy, what are you going to do with those rights? So, for example, same-sex marriage. Same-sex marriage was United States Supreme Court in 2015, Lawrence versus Texas. The United States Supreme Court said that it's a fundamental right. It's protected by the 14th Amendment, the same amendment that we're discussing. And there's a whole bunch of other cases also which are under this, under the idea of privacy. So, for example, there is right to engage in private consensual sexual acts. There is the right to marry a person of a different race, the right to marry while in prison, the right to obtain contraceptives. There's a whole list of cases, but let's just take the case of same-sex marriage because it's literally the same 14th Amendment which the United States Supreme Court held there is a right. Now, I ask you, if we use the same logic that the United States Supreme Court uses in Dobbs to say that abortion is not a right, it's not a fundamental right under the 14th Amendment. Why? Because it fails that it's not deeply rooted in our history and tradition. So let me ask you, is same-sex marriage also deeply rooted in our history and tradition? And the court themselves answered this question that no, it's not. So if you look at the case Lawrence versus Texas, they say the following: the issue presented is whether the federal constitution confers a fundamental right upon homosexuals to engage in sodomy and hence invalidates the laws of the many states that still make such conduct illegal and have done so for a very long time. Prescriptions against that conduct have ancient roots. So there's ancient roots against homosexual marriage, same-sex marriage. And nevertheless, the United States Supreme Court found that there is a fundamental right. And they didn't run through this analysis. I mean, in Dobbs, they didn't run through this analysis as it respects to same-sex marriage. And they should have. According to their reasoning, they should have. And therefore, they should have found, well, it's not deeply rooted in our history and tradition, and therefore, there should be no right for that. And take away that right too. But what did they do? So this is what they said. They knew that this was a problem, the Dobbs decision. They knew that this was a problem. So this is what they said. They say, no. What sharply distinguishes the abortion right from the rights recognized in the cases on which Roe and Casey rely is something that both those decisions acknowledged. Abortion is different because it destroys what Roe termed potential life, and what the law challenged in this case calls an unborn human being. None of the other decisions cited by Roe and Casey involved the critical moral question posed by abortion. They are therefore inopposite. They do not support the right to obtain an abortion, and by the same token, our conclusion that the Constitution does not confer such a right does not undermine them in any way. And then they conclude, nothing in this opinion should be understood to cast doubt on precedents that do not concern abortion. So essentially what they're saying is that this opinion is only with respect to abortion. Don't start trying to apply it to anything else. You know why? Because abortion involves the destruction of potential life, or what the Roe case calls an unborn human being. So here's the problem. You're right that is a distinction between, let's call same-sex marriage and abortion. You're right that that's a distinction. One involves obviously the destroying of an unborn human or potential life, and one doesn't. But really, why should that make a difference? Why should that really make a difference? If this is the process in which you have to go through in order to determine whether something is a substantive right, then you should go through the process. And if you go through that process, you're going to find that same-sex marriage is not deeply rooted in our history and tradition. And nevertheless, the United States Supreme Court found that it's a fundamental right. Well, if it's a fundamental right and you're going through that analysis, how can you go through a different analysis when it comes to abortion? You got to pick your analysis and stick with it. So this is the part which seems to be, doesn't really add up in my mind. If they're going through this analysis and they really just open the door on all of these fundamental rights that came out of this right of privacy under the 14th Amendment, and they should review all of them. And in fact, that is what Justice Thomas says. Justice Thomas in his concurrence says, we should really review everything and basically throw everything out, because these aren't rights that were guaranteed by the Constitution. And he argues on the whole idea of substantive due process in the first place. But nevertheless, I'm just talking about from a logical standpoint. If you're using the logic of Dobbs, then it should not end by abortion. And therefore, that's where this debate, I think that's really where the debate should belong. The debate should belong that if Dobbs is right, why stop by abortion? And the difference between, well, one obviously is destroying a potential life for an unborn child, that shouldn't make the difference, because that's not really what the process is in determining whether something is a substantive right. The process is very clearly laid out in Dobbs that you follow. Is this deeply rooted in our history and tradition? And the second part, is it essential to our nation's scheme of order liberty? And since it isn't, so you definitely should have an argument. If Dobbs is right, so then I'm going to throw out all these other protections that the right of privacy, the United States Supreme Court found is a right of privacy and is a fundamental right under the 14th Amendment. So that really is the issue. That's really the debated topic. And however, you most likely are not going to be hearing this on the debate stage. If I had to guess, probably not going to be hearing this discussion. It's just going to be about, what do you feel about abortion? Do you feel that the right should be to choose? The right should be for a life, pro-life, pro-choice. And that's essentially what we're going to be hearing, the same talking points that we've been always hearing in these presidential debates. But that is my take on this. I think it's a very interesting decision, very interesting how this all works out, but still left with some very important questions that we all have to think about and see if the United States Supreme Court does anything different as the cases continue to go up to them. So that is it for now. Thank you for watching. If you haven't yet, please subscribe, like, and we will see you next time.